Of course, now CRT appears frequently. The attacks on CRT have been part of legislative efforts at the state, local, and national level to suppress it. And we have a project here at UCLA Law School called the CRT Forward Project, which I highly recommend all of you check out. If you just Google CRT Forward, it will take you to our tracking project, in which we have been tracking these anti-CRT measures since 2021. And over the past 3 years, there have been nearly 800 different ordinances, statutes, resolutions. They've been introduced in 49 out of 50 states. Again, they've been introduced at the local level. There's also been a piece of national legislation. And of that 800, there have been quite a number that have passed. And yet still most people don't know what CRT is. And I would say that's especially true of those who have targeted it. If you stop these people that are waving the signs about banning CRT and ask them what it is, they're going to give you a blank look. But if we take a look at both what CRT is and how it has been caricatured and conscripted into this sort of moment of a certain kind of agenda, it becomes apparent that the attack on CRT was really part of a larger project of reaction to the 2020 moment of racial reckoning that happened in the wake of the murder of George Floyd. And so we understand through the work of NCBL and other organizations that the murder of George Floyd was not exceptional. In fact, what made it stand out was that it illustrated that there was a system of ongoing pattern of state-sanctioned violence against Black people. And that is connected very much to the project of CRT. That is, CRT has basically centered itself. It came out of a movement of law professors of color in the 70s, some of which was very much inspired by the work of Derek Bell, whose name is part of this panel, to really challenge the idea that the United States was on some kind of self-correcting project of correcting its past, or that the project of anti-racism had been completed somehow by the social movements of the 60s and 70s. And one of the things that CRT rejected was the idea that racism could be simply understood as the action of one bigoted individual against another. Instead, critical race theory was looking at the ways in which the law itself, and even anti-discrimination law itself, had sanctioned and legitimized certain forms of racial oppression and racial violence, and that this was in fact part of a long historic pattern in this country. And so instead of talking about racism as a simple kind of act of one individual bigot towards another racially subordinated person, we understood racism to be systemic. That is not a bug, but a feature of the system, built into its laws, not only during the period of slavery, but in the period following slavery, when we moved not only in the period before Brown under de jure segregation, but in the period after Brown, where we moved from a system of explicitly racist laws to a set of laws that were formally racially neutral, but that still had very racially disproportionate and racist effects. And it was that move that really challenged a lot of the picture of law that was painted by liberal racial reformists. So liberal racial reformists said, well, look, we went from Brown to a post-Brown era. We've gotten rid of the racism in law. And critical race theory said, actually, no, you did not. We have not. And what we see in the wake of what's been called the Second Reconstruction, that is that period of the 60s where the legislative products of struggle, like the Voting Rights Act, like the Civil Rights Act of 1964, were in fact imperfect representations of the aspirations of people for change, but even themselves became engines for a certain kind of racial status quo that was designed to lock people in to the kind of system that ultimately we saw in George Floyd. That is to say, the inability of law to check certain kinds of forms of state violence and state discrimination was precisely what critical race theory was designed to address. The other piece of critical race theory, in addition to this move from looking at race as simply an individual action to one that is systemic, is we also were looking at the ways in which there was a certain pattern of legal reform that was followed by reaction. This too is something that we saw in the period from 2020 till now, and certainly the election of the fascist regime of Donald Trump yet again. Kim Crenshaw's classic article, Race Reform and Retrenchment, describes an earlier version of this moment in which, as I said, the partial gains of the Second Reconstruction, that is, the Voting Rights Act, the Civil Rights Act, were attacked by reactionary forces and a form of racial retrenchment of the Reagan era, of Ronald Reagan, in which the Reagan administration used the very agencies that were designed to enforce civil rights for racially oppressed people to undo those rights. And thus, for example, that's the period that Clarence Thomas began his career as the head of the EEOC and took it as his mission to undo the agency's work. Of course, pursuing the added benefit of sexually harassing his female employees. The point I'm making here is that the attack on CRT now follows this pattern. That is, once there is a pattern of racial reform, as Crenshaw points out, there is often a reaction, a period of retrenchment. And this is something that we definitely see. I can talk more, but I would say that I want to allow Justin to add on here. But one of the targets of critical race theory was this idea of colorblindness. That is the idea that, race is simply color and color doesn't matter. And that the law has basically embraced, particularly over the last 4 decades, we can see this in the Supreme Court's decisions and doctrines, a rejection of the idea of structural racism and the idea that the attention to race itself, that is any form of race consciousness, is itself racism. So CRT had all of these things within its target, and the attack on CRT basically proceeded in the way we understand forms or any move towards racial reform is often met with a period of reaction. So, Justin, I wanted to allow you to say something about what CRT is as well.
That was obviously perfect. For me, I think about, and many of you may also think about some of the core takeaways from CRT concepts, starting with Derek Bell and his idea of interest convergence, all the way through Kimberly Crenshaw, her concept of intersectionality, and even, of course, our own Cheryl here who spoke about the importance of understanding how race itself, in particular whiteness, has a function that is very similar to the way property rights function in the law in terms of the understanding of ownership and property. So these ideas that have been activated through activism in our communities. CRT itself comes out of social movements, our racial movements, movements for reparations, movements for affirmative action, movements for a response to state violence and police violence. And critical race theory has also manifested itself, I believe, in an approach to lawyering, which we call movement lawyering. Now, movement lawyering has been around for years, going back to some of the people that come out of Howard University, even mentioning Thurgood Marshall, who is, of course, our most famous alum at Howard, and Charles Hamilton Houston, and Pauline Murray, and others who have blazed our trail. But in terms of applying critical race theory concepts like interest convergence, like some of the concepts I mentioned earlier, using narrative for the express purposes of creating a counter to racialized narratives that are being mobilized to entrench racial hierarchy, creating counter narrative as part of your practice. Many of these concepts grew out of the work of makers in the 80s and early 90s and mid 90s. And we're still seeing the application of those concepts today in the type of lawyering that is being practiced by members of NCBL. So, that's something that's been part of our legacy. Some of you may also be familiar with other formations like Law for Black Lives, and other formations that have uplifted movement lawyering in recent years, especially coming out of the Black Lives Matter movement. All of that is part of the heritage of critical race theory.
Thank you. Our next question, as we reflect on the post-Students for Fair Admission line of lawsuits, the lawsuit against the city of Evanston's reparation suit, the lawsuit filed against Northwestern Law School, alleging that white candidates for professor of law were victims of discrimination, what can we learn about the legal lines of attack we can expect in Trump's upcoming term?
Should I take that one, Cheryl?
Yeah, why don't you start with that one?
All right. Yeah, so the attack that we've seen over the last few years, interestingly enough, building off of what Cheryl had mentioned, really has taken this concept of colorblindness, which there's a long history in the 20th century of seeing that concept weaponized, really going back to Plessy versus Ferguson, and the application of this concept of colorblindness to Jim Crow, and of course we know, very faulty idea we could have separate but equal, all the way to SFFA, which essentially, as Cheryl said, has made the assertion that any mention of race is racism, including using race to seek to provide remedies to those racial harms. Now that ruling, the Students for Fair Admissions ruling, which, as you well know, essentially ended the diversity rationale's status as a compelling state interest, which would allow for it to survive a constitutional test under the 14th Amendment. That ruling is now being sought to extend to all elements of American society, beyond simply university admissions. We've seen efforts to extend it to the space of employment, attacking companies' DEI programs. We've seen it sought to be extended to municipal reparations efforts. As many of you know, of course, there in North Carolina, you have Asheville and other places that are talking about reparations programs on the municipal level. And we also have seen efforts to extend this idea of colorblindness through the hiring process at law schools. Northwestern University, most notably, has been the test case there. And we've also seen it being applied to the work of philanthropists. In particular, there was a case involving the Fearless Fund, a philanthropy that gave $20,000 grants to African American women who were creating startup businesses. So all of these challenges, so those four challenges have happened over the course of the past year and a half, 2 years. And each of those challenges have essentially argued that these efforts that took race into account in some way, shape, or form were just in violation of the 14th Amendment. in light of SFFA. Now, there are many arguments that have been made in response to that, which focus on legal doctrine itself. One of the more interesting arguments, one that has been very relevant to the reparations debate, starting with the reparations case coming out of Evanston, Illinois. Evanston, Illinois is, as you know, the municipality which passed what many people consider to be the first 21st century reparations ordinance seeking to provide a remedy for redlining and provide a reparations response to that particular harm. That blueprint has been the blueprint that reparations commissions around the country in general have followed. There are 29 cities across the country that have created reparations commissions. And of course, you know that the state of California, the state of New York, and the state of Illinois have statewide commissions. Many of them use a legal justification that's similar to the one used in Evanston. And so the lawsuit against Evanston's Reparations Commission was filed as a sort of warning shot to all of these commissions. And you can look at all of the lawsuits that were filed as warning shots in the area of law school hiring, in the case of the Northwestern case, in the area of philanthropic giving, in the case of Fearless Fund, in other cases that I've mentioned. You know, you've seen that entire industries, the reparations world, the philanthropic world, the world of law school hiring, and entire industries have responded to these lawsuits as if they themselves were the ones being sued. And they have been, in many cases, obeying in advance, is one way to put it. And they have decided to pull back on their efforts in advance. So that pattern is one which has predated Trump's election. And of course, Trump's now being in office, and I know Cheryl will talk about this in more depth, but he is in a position to add the administrative level of attack to the judicial level of attack. And with the Senate being now dominated by Republicans, and perhaps the House of Representatives, we may also see the legislative level of attack added, forming a complete triumvirate of all branches of government participating in this one campaign, which once again is a campaign for colorblindness, which is again, it's a concept which they will not articulate as such. They in many cases they will go so far as to quote Martin Luther King Jr. and say that their goal is to allow for society to make decisions based on the content of character and not the color of their skin. Highly offensive to use Dr. King's quote in a backhanded way like that. But this ultimately, critical race theory is what allows us to understand what the core of their concept is, which they're trying to promulgate through law, using all three branches of the U.S. government. And again, perhaps in the future we can go into more detail on the doctrinal elements of these cases. I thought it would be good just to start from a broad view.
Yeah, I think, Justin, you've given a good overview of some of the current litigation. I guess I would just add briefly that what Trump's administration will do is provide an accelerant to an already existing line of attack, which is basically a radical reactionary form of colorblindness. As Justin mentioned, the idea of colorblindness has been around a long time. It appears, of course, famously in Justice Harlan's dissent in Plessy versus Ferguson, where he denounces de jure segregation with the phrase, "Our Constitution is colorblind." He's the only dissenter in that opinion. What we've seen over the years is how colorblindness has sometimes been used by anti-racist forces to argue against de jure segregation. What we're in a period now is how that term and idea has been co-opted to a reactionary project in which anti-racism itself is being deemed as racist. And so all these varying forms of litigation are likely to gain additional steam. And as Justin mentioned, one of the things I think we can anticipate is all of the federal agencies that are now, under the control of the federal government. We know from Project 2025 that one of the objectives of the Trump administration will be to hollow out the civil service with respect to people who have been in these agencies, say, for example, the Office of Civil Rights of the Department of Education or the EEOC. Now, we all can have critiques of these agencies. They are far from perfect in terms of delivering actual benefits for our people, but they stand nonetheless as a kind of a normative statement against certain forms of oppression. Title IX, for example, with respect to sex discrimination. The project of 2025 has indicated that they intend to basically hollow it out and appoint people that are loyal to them. And so what we will see is an even further tightening of the organs of the state, a way in which they are mobilized to legitimate this notion that any attention to race itself is racism. And so I think what we can anticipate is actually of a range of activities. And in fact, Project 2025 sort of lays out in some specificity what some of these targets will be. So I think one of the things that we've always known is that the courts are not the allies here, but nonetheless, we can, I think, look at the ways in which these arguments have been really heightened. One of the things I did want to mention is that, and just to underscore, is that the purpose of a lot of this litigation, much of which is funded by Ed Bloom, the same forces that funded the SFFA litigation and the case against the Voting Rights Act several years ago, Shelby County, that was also funded by Bloom. A lot of these, the object of these lawsuits, and if you read some of these complaints, they're very, I guess I would say, haphazardly written. They often make claims that are absolutely ridiculous or unfounded, but it doesn't really matter because part of the purpose of the lawsuit is to, as Justin pointed out, engender anticipatory compliance, meaning it's designed to intimidate institutions and agencies into eliminating any program that looks like it might be attending to questions of racial subordination and get people to basically withdraw even the very limited efforts that have already been made in anticipation of litigation. So I think some of the fights that we will also see will be to try to get institutions to hold the line because some of these lawsuits, particularly the one, for example, against Northwestern University Law School, alleging that white applicants have been discriminated against in Northwestern's hiring practices, are really ludicrous if you actually take a look at the number of Black people or people of color that have been hired at Northwestern. It's an institution that has been notorious for lacking racial diversity in its faculty. The idea that somehow the 2 or 3 Black folks that are on the faculty there have gotten there by a force of discriminating against white candidates is absolutely absurd. But nonetheless, it still is a warning sign to other institutions about essentially placing a kind of barrier, not just to affirmative action, but to any consideration of any candidate of color.
Thank you.
And I was going to add one more thing to that really quickly as well. I mean, another, just to build on Cheryl's point, the lawsuits, they do border on frivolous lawsuits that, there was even a discussion amongst some of the lawyers in the case against Evanston as to whether to file an ethics complaint, because the lawsuits are alleging, in many cases, facts that really do not follow the SFFA ruling. So just to be clear, that ruling, of course, number one, it's not clear that the ruling would extend beyond university admissions to other areas. Number two, the ruling did not eliminate all uses of race. What the ruling did was eliminate, and for general purposes, the idea that promotion of diversity is a compelling state interest. But however, there was the understanding in the case that there are situations when there are measurable, concrete interests that can be used to justify considerations of race. For example, building off of another Supreme Court case, Richmond versus Crossan, there are situations in which there were specific, tangible, concrete, measurable harms that were perpetrated, and if in response to that, a city like Evanston sought to provide narrowly tailored remedies for those harms, then that would what we worked hard to do in Evanston. I was lucky, the Thurgood Marshall Center was lucky enough to help the city of Evanston craft its response. What we were able to do was to ensure that the city drafted a detailed report acknowledging the harms of redlining in the city, and thereby establishing that there is a measurable, concrete, specific harm that's identifiable here. And as long as the remedy is narrowly tailored to provide a response to those harms, it would be constitutional. And that is the format that many of the other cities around the country, including Asheville, have used as a guide. So the lawsuit itself, simply upon its filing, was used to send out press releases to the entire country saying that essentially that all of these reparations efforts were going to face constitutional challenge and they're likely to be overturned, scaring people, when the reality is the lawsuit is still ongoing, but in no way, shape, or form can we predict with confidence that that lawsuit would be successful at this stage of litigation. So that's just one example. I mean, even the SFFA opinion itself carved out exceptions for the military. Now there is a case against the Navy that Ed Bloom has brought with a possible motive to try to find a way to eliminate even that carve out. But it's not at all clear that SFFA opinion foreclosed all avenues, and it's being messaged as if it is a case that forecloses all avenues towards racial remedies, and that's not at all the case, in my view.
Before we move to our next question, are there any questions from the audience that anyone may have? Because Mr. Hansford is on a tight time restraint and has to be early. Seeing none. What does Project 2025 portend about the incoming legislative and administrative attacks on efforts to create racial justice? And how does the attack on CRT feature in this attack? Parental rights, defunding DEI and higher education, direct and indirect, through controls on funding.
Well, to some extent, I think we kind of started talking about the way in which the forces of the administrative state are likely to be marshaled here. And I guess I would say that part of this goes back to, the genesis of the attack on CRT. If you actually take a look at Project 2025, there are places where CRT is explicitly mentioned, and it's particularly mentioned in the education section, which goes to what this attack on CRT did. So just to go back a little bit, if we go back to when we start to see this attack emerge, it was again, once BLM and the massive social movement of the spring of 2020 seemed to begin to break through rejecting the sort of official line of colorblindness and putting the language of systemic or structural racism on the table. I don't know if you recall, but this is when we actually start to see this idea emerge in public discourse. And both of these ideas, that is the attack on colorblindness and the understanding of racism as structural, both of these being central to critical race theory, the reactive forces, particularly the Trump administration, which was then in power, began to cast around for an effective response. And they found a ready script that had been developed by a group of disaffected right-wing journalists, including Christopher Rufo, whose name you might have seen, who had been railing against the alleged mistreatment of white men by DEI trainers. He had alleged that basically DEI was demonizing white people as victims. So he had managed to get on Fox News, and in the summer of 2020, one of his presentations apparently came to Trump's attention. And so you see, basically by early July, Trump starting to rant about CRT as a divisive idea designed to teach students to hate white people. This is also when you see them mobilizing the 1776 Project, which was identified as a direct counter to the 1619 Project that Nicole Hannah-Jones and others had launched. So it didn't, I can recall actually seeing Trump give a speech on the 4th of July. This was televised. He was in front of Mount Rushmore, and he was denouncing CRT. Well, of course, we know he never read any CRT. Nobody around him ever read any CRT. It had really to do with the conscription of the idea of CRT as a way of pushing back against the movement. And in fact, the fact that it didn't matter that there was no actual understanding or target of CRT. So this is not like the typical academic debate where, you have one academic on one side arguing one interpretation and one on the other side arguing another. Rufo, in fact, admitted as much in a series of very now infamous tweets that the project was to render the term CRT toxic and to load it up with every idea that was deemed to be crazy by the American public. So it was kind of a howling out of CRT itself to just the label. And so what did they do? Well, Trump passed an executive order which banned the teaching of CRT or any what he called divisive concepts in any federal agency or by any federal grantee. I want to underscore that, by any federal grantee. Now, who is a federal grantee? That's every college and university in the country, right? Every college and university in the country gets some form of federal money. So it was an attempt to basically demonize this idea and to reach into the entire educational structure and say this idea is anathema. What happened was that this move got stopped by a federal judge who said this was unconstitutional, but really that was only the beginning of the story. And I think what some people missed at the time was that they thought, okay, now we've shut down this executive order, Biden has been elected, he's overturned the executive order, this is all gonna go away. Nothing could have been further from the truth. It actually became a template for how similar legislation at the state and local level was to be created, and to create a kind of climate of national hysteria about the poisoning of young children's minds with these dangerous ideas. There was a proliferation of a lot of how-to booklets that taught conservative activists how to raise these claims at the local school board level. And again, the underlying broad message was that any form of anti-racist education was actually racist education, and therefore had to be excised. So it was used to basically popularize this idea, to basically move it into the local school board level. I'm sure many of you have been in places where you've seen news coverage of some of these school boards where people are waving signs saying ban CRT. They have no idea what it is, and it doesn't matter, because what the project here, and going back to the question here specifically, which we see articulated in Project 2025, is to continue this attack on CRT under the rubric of parental rights. So the idea is that parents have a right to control what their children learn, therefore they have a right to articulate that this kind of instruction is to be banned. Now, if you actually read the text of some of these laws, They say things like, no instructor shall teach that one person is better than another person by virtue of their race. I'm sort of butchering it, but that's basically the idea. Well, of course, critical race theory doesn't teach that at all. But it doesn't matter. It is invoked in a way in which to argue for this kind of parental rights. And that project itself, the parental rights project itself, is tied to the overall attack on public education. That is that we should move to charter schools. We should take basically the idea of the common school, which of course comes out of the Reconstruction, and replace it with a privatized system in which parents have the right to sort of control curriculum, control hiring. And by the way, I should just say parenthetically, the idea that parents should have a say in their children's education is actually it's not objectionable. That is not something that I think any reasonable person would object to. What has happened here, however, is that this particular framework has been mobilized to argue for a kind of radical restructuring of the public school system, which of course, who is going to be left behind in that project? We know that. We already know that. The second piece of this that you see in Project 2025 is the continued defunding of DEI. Specifically in 2025, it talks about that the way in which the federal government funnels money to different educational institutions, specifically colleges and universities, has allowed for the universities to fund DEI efforts. So one of the remedies so-called remedies that Project 2025 is talking about is to reduce the amount of indirect funding that goes to federally funded universities, which of course, as I said, is virtually every university in the country. So it's a way of contracting the money, the public money going to these universities, which in turn they say have been using the money to fund DEI. So not only is this a project which is designed to reshape what's happening at the K-12 level, and of course we've read before about eliminating the Department of Education, that's the top of the list, but it's also about restricting the funding sources to colleges and universities. There will probably also be other kinds of efforts under the Project 2025 project to support the efforts at the state to restrict anti-racist education. Because the federal government funds, it's not the same, I guess I would say, as a kind of direct attack like the executive order. But through the funding stream, the federal government has a great deal of influence over what states do with their education. And so restricting the Office of Civil Rights of the Department of Education, in fact, eliminating the Department of Education, restricting the Office of Civil Rights Enforcement, all of this is designed to remove the administrative structure that has focused on race and racial inequality. So I think we can anticipate that what they have written they intend to do, they will do.
Yeah, and just to build off of that, that brilliant analysis, I mean, this is the way I read it, if we had to think of a theme for the Project 2025 instinct, it's deregulation. And of course that will happen in the financial sector as well. And what you're seeing is it being applied to the education sector. And of course, the understanding is that in that vacuum, that provides space for private domination of the sector. And really the connection between the critical race theory concept of reform and retrenchment is very clear. All of us can connect the dots between what we saw as something of a racial reckoning in 2020 and the creation of reparations commissions and DEI programs and people's understanding about the realities of structural racism. All of that is part of one major push towards reform that happened after the killing of George Floyd. And so the white lash, the response to that, is being seen here through the anti-CRT campaign and its translation of those same ideas. Again, just like the idea of parental rights is a veneer that seems unobjectionable, the concept of colorblindness, the quoting of Dr. Martin Luther King, all of these types of rhetorical terms are terms that are not just something that is seen as acceptable in broad society, but even in wide swaths of the Democratic Party, even in wide swaths of the liberal establishment. They do not have a counter-argument for the colorblindness statement. They do not have a counter-argument for the parental rights statement. So they're taking these concepts where they know that their political opponents do not have a counter-argument, because even though they may have mouthed some understanding of structural racism and critical race theory in 2020, they didn't really understand the core of those concepts. We see that in the Democratic Party and its failures this past week. They did not fully embrace the lessons of critical race theory. They're still caught in a liberal ideology, which leaves them susceptible to having no defense. So that's one of the major ways these offenses are gaining so much traction, both on the right and in the liberal, and in some cases in the Democratic Party that would be their only real opponent on the political platform.
Thank you. Moving to our last, we have a question from the audience.
Yeah, I wanted to ask a question for either one of the panelists about the role of the Obama administration, and if they see that as an instance of interest convergence and how they would make sense of the backlash, or do they see part of this backlash that Dr. Harris talked about, starting up with the rise of the Black Lives Matter movement, having these deeper roots in a response to Barack Obama as a graduate of Harvard. I remember some early discussions about him being associated with Derek Bell and things like that. So I just wanted their thoughts on that.
It's a great question, and I think the cycle that I was trying to describe of race reform and then reaction obviously has antecedents to 2020, and I think you've just identified one. So, we can understand Barack Obama's rise as perhaps a moment of interest convergence, and just for, and to sort of bring everybody into the conversation. This idea was really espoused by Derek Bell in a classic essay on Brown versus Board of Education, where he takes up a debate that's happening among academics, in which a famous law professor wrote an article that said, I really like the result in Brown versus Board of Education, but I can't, for the life of me, see it as a principled position. It just looks like a political decision dressed up as the legal decision, because this is really a case, this academic argued, of the preferences of white parents for segregation versus the preferences of Black parents for desegregation, and the Constitution doesn't tell us which one of these we should value more than the other. Well, there was another academic that wrote and said, this is stupid, this is nonsense. We understand that the Constitution rejects subordination, and segregation is a form of subordination, it's not equal treatment. Well, Bell's article basically entered into this argument and said, well, the second professor is right. The Constitution does have a very clear answer on this question, but the first professor, the one that framed these things as kind of equally competing questions, equally competing preferences, he's actually got his finger on the way that the dominant white society looks at this. It looks at the question of any form of racial reform as simply one preference versus another. And this idea of neutral principles, which the law supposedly embraces, is actually the way that the court treats it and the way that a lot of people look at it. So it looks at Brown as a political decision, not a legal decision. And Derek then raised the question then of what does this kind of debate tell us? What does this debate show us? And he argued that racial reform really only occurs when there is an alignment of the advocates for racial justice with the interest of the dominant society. And so he analyzes Brown not as a result of necessarily sort of a triumph of the Equal Protection Clause of the 14th Amendment. He analyzes it from a realist perspective and says what actually happened is that in the wake of the World War II and the emergence of the Cold War with the Soviet Union, the United States was on the back foot when it came to trying to compete for influence with the emerging nations of the developing world. So he looks at the State Department's brief that was filed in Brown versus Board of Education, which argued for desegregation, basically on the grounds that when they were trying to influence Ghana and some of the other post-colonial states that were emerging in Africa and Asia, that the State Department was saying, we can't compete because the Soviet Union is showing pictures of children being set upon by dogs in Mississippi, and we cannot make any headway politically. So Derek takes this argument and says, this is how sometimes racial reform change occurs. In fact, the only way it occurs is when there is an alignment between the interest of dominant elites, whites, and the interest of racial justice advocates. So the point that I think your question raises is, how do we understand that Obama's election against the backdrop of a legacy of white supremacy? Well, certainly there was a moment, if we consider what was happening at the time, the Great Recession, the collapse of the economy, the need to sort of save capitalism from itself. You have a moment where Barack Obama emerges as a figure which repudiates the notion, ostensibly on the surface, of capitalism as a racist project, and also allows for the continuation of some kind of form of, I guess I would say, democratic performance. And so Obama himself, as we know in terms of his actual policies, actually didn't, the one major thing I think we can point to is Obamacare. But apart from that, many of his policies and most of the ways in which he presented, in which his administration functioned, was to repudiate any kind of really serious racial critique. In fact, that was something that he often distanced himself from. And the price of that, to go back to Justin's point, is that the lack of there being any articulation of an opposition to the radical forms of colorblindness, which were then on the ascendancy. So what we have, though, in the complicated part about Obama, who presented a kind of form of racial compromise with the liberal ideal, is you also have, following Obama, the rise of the radical right, the rise of the Tea Party, which then takes over the Republican Party and lays the groundwork for MAGA. So the reaction very much, I think, represents the election of Obama as a kind of moment of racial reform, although I want to really put some qualifiers around that because of the ways in which the Obama administration actually enacted or I guess I would say the policies themselves. But the reaction to it is very, very much, I think, indication of the ways in which interest convergence tells us that these things happen in certain moments, but that once the interest of dominant elites changes or starts to be perceived differently, the impetus for reform actually wanes. And so we're in a moment where, at least in terms of the current political landscape, there is no sort of perceived dominant elite interest in anti-racism.
Right. And I just want to build on that, and I saw Adjoa Adetorah there in the back. I want to wave to her. Glad that she's here. We have so much we can learn from these lessons. Even, and I speak specifically to the reparations movement, which is something I'm very interested in. Adjoa and I have been talking to some of the lawyers defending the Evanston reparations plan. Right now, there is, it seems, some type of interest convergence between the interests of the lawyers who are representing the city, which does want to defend its own interests, to defend its policies, and Adjoa, myself, and other movement lawyers who have the interests of the reparations movement at our forefront. So right now, there seems to be a convergence of interests that allows us to see a way to collaborate this institution, this city government wants to work with us. There are other cases, perhaps say, maybe Northwestern University, some other situations where their interests, the interests of the institution, in that case, the university, to defend itself against the lawsuit, does not align with the interests of the movement. In the sense, they're trying to distance themselves from the law professors of color, the Black women law professors, Jamila Morgan in particular, who are seeking to simply maintain their dignity under these attacks that are trying to undermine their credibility. And in that situation, the interests do not align. So the interest convergence concept is so powerful because it not only applies to these broad societal political questions, I believe it also applies to individual movement, lawyer, practice questions that we can look at on a day-to-day basis, as well as the critique of traditional civil rights laws. As radical lawyers, we have to learn how to use civil rights laws, even if it's look at it sort of like a double consciousness from like W.B. Du Bois used to talk about. Be aware of using civil rights laws and civil rights institutions like the DOJ Department of Civil Rights under Kristen Clark right now. There are situations where there's a mainstream civil rights narrative, but we have our more accurate radical narrative that we have to be able to use those mainstream tools or be able to be willing to critique those mainstream tools even as we use them. And of course, all of our work being grounded in our understanding of our Black radical tradition as a lifting off point. All of these concepts that come out of critical race theory not only animate a very incisive analysis of national political questions, but they also can animate our individual practice on a day-to-day basis.
Any other questions before we go to we have another question in the audience.
Yeah, I'm Jalil Muta King, and I'd like to raise a question. We talked about interest convergence, right? How does that apply for us Africans here in America in terms of our understanding our own class divisions and having our own self-interest in conversion on that level? I mean, we talking about converging with white folks. Well, what about converging with our own Black elite, converging with our own underclass in terms of the petty bourgeoisie and our working class? How do we evolve the kind of unity that we need to have in terms of a popular evolving of a movement that it will change the basic the plantation in regards to their relationship to Black people, brown people, and indigenous people in this country? All right, where is it our convergence? I mean, that's what we need to really focus on, I think, in terms of our relationship to others, right? Who are the dominant force, the dominant influences of this country, particularly white people and white supremacy. So I think if we don't have class unity, then how are we going to expect ourselves to be able to combat and struggle against white oppression?
I think it's a fair question. I guess I would start by saying my understanding of interest convergence is that it is diagnostic. It is looking at patterns, historical patterns, and as Justin said, trying to give us some insight into analyzing current struggles. It's not prescriptive in the sense of saying, this is what we should therefore do. I think the larger question that you raise is the question of the complexity of the Black movement and the complexity of Black communities and the complexities of the Black freedom struggle. And historically, we understand often that to talk about the Black community is often to speak in terms as though there is a unified consciousness when that is actually not the case. One of the things that I think is very helpful to think about, at least for me, and I just offer this, is to think about racial formations as themselves a kind of coalition. That is to say, we come to it with different experiences, different understandings, and we cannot presume that everybody's position is the same. How do you work in coalition? You try to find points of commonality. You try to find and mobilize around points of commonality. Intersectionality is actually a concept which is trying to get at the idea that we cannot and ought not presume that simply because of our racial identity, that each of us is exactly situated the same. There are divisions with regard to gender, sexual orientation, class, immigrant status, a whole range of things. And in order to form a powerful coalition, one has to acknowledge and recognize those differences, not seek to pretend as though they're not there. And so I think in response, my own view would be that interest convergence is not a political project or a political program. It simply is a diagnostic tool that helps us understand what we might have to encounter in the course of pushing forward. And it allows us, I think, to, as Justin says, understand at the level of sort of individual practice where there might be space to move, right? Where there might be a moment to exploit, if you will, a particular kind of convergence that allows us to make certain kinds of arguments or certain kinds of advances. But it is not in any way a prescriptive political ideology.
And then I would just, actually, I really want to ask Cheryl this question. Cheryl, would you make the same statement about critical race theory as a whole as being more diagnostic than prescriptive? Or do you think there's critical race theory? Because of course, in you know, the popular parlance, they are framing critical race theory as a political project. Would you?
Yeah, that's interesting. I think of it as both in some respects, because there's such a wide range of work within it. You know, there's one of the major voices that was influential with me was John Calmore, who's based there in North Carolina, actually, whose work actually, I think, crossed both the diagnostic and the prescriptive. He wrote a lot about sort of understanding this way of kind of building coalition. And I think that there are, in fact, very clear implications from some of the work in critical race theory about a way forward. But, you know, part of this gets to the whole, I guess I would say, long-standing debate about, you know, what's the relationship between theory and practice. And if there is a strong relationship between theory and practice, then we can see. One thing I will say, just, you know, my own little soapbox, is that sometimes I think there is a tendency to, let me put it this way. My understanding is that theory comes out of practice. That is to say, studying history and practice actually gives us a window into theory. Theory does not always sort of lay out a pathway precisely for what to do. It can give you, I think it can give us some ideas, but really theory, good theory, actually comes out of looking at practice. And so, you know, part of what I think, and that often is a challenge because, you know, there's a very strong kind of anti-theory strain in the anti-CRT attack. You know, it's like these academics are just, you know, sitting back in their ivory towers and espousing ridiculous ideas. All the while, the right is funding its theoreticians to the hilt. All the while, they are building these think tanks to generate all kinds of theories and ideas. All the while, they are, you know, denouncing anti-racist theory. I find it ironic. Anyway, that's just my soapbox.
Right. No, thank you. And you know, on my side, to answer a little bit to the brother's question, John Calmore, in fact, of the concept of intersectionality in a way that in some of his work emphasized how identity vectors include class as well as race and gender. In one particular article, he wrote about the Black urban inner city concentrated poverty context. And it's a larger article called A Call to Context. And in that article, he talked about that's a particular predicament with the way that poverty is racialized in urban settings is different from the way that a black person who is not in a concentrated poverty environment is racialized, right? And I tell my students in my movement warrior clinic, we're working in a public housing project that's out to sea. And I tell them that what they're observing in that environment as we try to do movement warring there is a certain way of understanding how racism plays out in that platform. But many of them are not from an urban area where there was concentrated poverty. And I was explaining to them that as a middle class, upper middle class black person who's, at our university and all these things, like they still need to understand how racialized narratives could play a role in their interactions with black people in that housing project in Southeast Washington D.C. Because that's class is a major issue, black community, as well as immigration status, as well as gender, as well as orientation. All these issues are issues that we have to acknowledge when we're organizing and when we're practicing, because they do play a role in the predicaments that people are in. The predicament of a queer black woman in a upper middle class environment is different from a predicament of a cisgender black man in an urban public housing project. They both are facing racialized predicaments. But there are nuances that are playing out that we need to be aware of. Critical race theory taught me that. Critical race theory taught me to be aware of those nuances that exist even under a state of racial apartheid.
Are there any other questions from the audience before we go to the last question? What does CRT teach more broadly as we try to make sense of this moment in history?
Well, can I go first? I'm going to hop off.
Please do.
Again, Cheryl is my teacher, so I'm usually defer to her. But so to me, in this day and age, I'll say what happened Tuesday, as difficult as it was to observe, it's because of CRT, as well as my understanding of the work of Marcus Garvey and Malcolm and others, that the whole Black radical tradition, which CRT is a part of. It's because of that I wasn't surprised. CRT is one of our. It's one of the things that we inherit as part of the history of Black intellectual contributions to our society. It's another artifact of Black culture. And what it has done for me is allow me to have a position of strength as I interact with what Dr. King called a burning house, and understand that there is a long line of people who have thought about these questions in a similar way that I'm thinking about them as a lawyer, right? Because again, all of these elements of our Black radical tradition, from Angela Davis, Marcus Garvey, all the way down Frederick Douglass, they're all ours. But as a lawyer, to me, the critical race theory is the lawyer side of the Black radical tradition, very firmly. So out of all of the pieces of the Black radical tradition that I take with me, critical race theory is the lawyer piece, And to me, that's what makes it special to me, because that's what I am. And so that gave me my animating force and strength to be able to get up Wednesday morning ready to fight. And even Tuesday night, it kept me. I was disappointed, but I wasn't probably as disappointed and crushed as some people who had not been exposed to these ideas and maybe had different types of expectations. To be honest about it. And again, I was on Howard University's campus, so I was right there during that event. And it was very difficult because, especially there were many young Black women there who saw themselves in Kamala. And, when that loss happened, it's like it was one less possibility for themselves. It's like many of them were saying, like, I want to be president, and that's like, that was an articulation of what they could be. And it was heartbreaking to see that happen because people were, doing the electric slide and, and they were really enjoying themselves in anticipation. And then, as the night got later and later, things changed. So it was heartbreaking to see that happen. But for me, individually, critical race theory gave me some level of defense that not all of our people had. So I'm very thankful for it, and I'm hoping that we can continue to spread it, even though there are going to be forces trying to censor it and destroy it over the next few years.
I'll just echo Justin and say that, when you're when we find ourselves shackled, to the edifice of the of the U.S. project and government. So we shed the shackles of enslavement, but we remain shackled in important ways to this project, and as it has turned more explicitly towards fascism. The question that we have is, how do we move forward? I think it's quite important to see, for me, critical race theory as an important tool in that question. And I hearken back to Derek Bell's important work. One of the other ideas that he espoused was the idea of racial realism. And by that, he meant simply understanding racism as not a sort of add-on to the American project, but as central to the American project. Again, a feature, not a bug. And the understanding then of why, in certain respects, the victories of the past have to be fought for in each generation. It's not an easy lesson, but it is, I think, as Justin was alluding to, an important one in terms of both understanding where we are in the historical arc of things, and understanding that just as our ancestors found a way in the wake of Plessy versus Ferguson and the nadir after Reconstruction and the period of reaction, that we ourselves can, in fact, and must, find within ourselves and within our community the clear, with a very clear eye on reality, nevertheless the understanding that our project is to do more than survive. I think our project, as we sit here, is really about the question of whether or not we will. So many of the policies that are on the table now have implications not just domestically but internationally, and I think we can understand how we are interconnected, how Black people in the United States are interconnected with the question of Black people globally, and what we then can look to, much as our ancestors did, in terms of inspiration and sources of connection. So I'll leave it at that.
Thank you. I'm going to open it up to the audience. If there are any questions that want to be raised. Have one.
Hey, how are you doing? Appreciate your remarks so far. One of the pieces for Derek Bell that I really appreciated, I believe it's called Ethical Ambition, the book where he's talking about what it means to live a meaningful life. And you're talking about interdependence and ways of relating with each other. And I'm curious, as someone who hasn't read a ton in the CRT space, how cooperative economics, solidarity economies fit into the conversation around sort of the build work that we need to do versus sort of the resist work. Yeah, that's it. That's the question.
In some ways, that you've answered your own question. I think it's a wonderful reminder that Derek's work not only spoke to the question of the past, but also has implications for our future. I guess I would just say that the idea of ethical ambition, as I understood the book, was really to try to respond to some extent to the critics of Bell that said that racial realism was really too pessimistic. It was sort of sounded like we were caught forever in an endless cycle of resistance and then, facing reaction. And without sort of mitigating that, because I think that very much is the dynamic. I think ethical ambition was his intervention to say, so then what are some of the threads of what we can pick up to do? What are some of the places where we can find the way to build community? And I think, frankly, I think the challenge of the present that we have is how do we sustain the core? What are some of the practices that we can engage in? And I look, in some ways to the ways in which culture plays a really critical and important role in that. I just mentioned before this idea of sort of looking beyond the boundaries of the United States. We're thinking about ideas and models for how we interact and how we build. None of this is going to be easy, but I guess I would just say that I think ethical ambition is his effort to try to gesture towards what are some of the practices that we can use to sustain ourselves. I don't have anything specifically to say with regard to cooperative kind of economic developments, but I think that to the extent that what we've been describing, Justin and I were describing, were sort of many dynamics happening at the national level and with the control of the federal government looking like it's going to be under Trump pretty much totally. That does mean that the space where we may find the most productive places where we may find space to work are at the local level. That is to say, I think looking very much at the local level is going to become an important piece of our struggle, and certainly cooperative developments are going to be a central part of that.
We have one other question.
I just wanted to flag something. I know that during this period when there has been pressure put on school boards under the banner of campaigning against CRT, that there have been a number of parents and movements and activists who have tried to fight back by advocating for inclusion of multicultural education curricula and Black education, Black history and other things in the school curriculum. The courts have not recognized a right for parents to demand that the curriculum includes certain things. They do have a right to have their kids educated within a public school system, but they can't direct or impose the curriculum. But one thing that does exist, and which we're seeing in a case that I have, is that when you have a situation where there has been some act of racial discrimination or hostility or something of that kind, and the school authorities have reacted to it, they responded to it by doing such things as increasing their DEI component or multicultural curriculum or something like that. If after they have taken that step, then they back off of that in response to the pressure that's put on them by the anti-critical race theory mob, if they back off of it, then that's regarded by the courts as an intentional act of discrimination. Because they have demonstrated that they're aware of the problem. They have taken steps to address the problem, but then they've made an affirmative decision not to do what's necessary in order to prevent discrimination within their school. So, whenever you have those situations, it's worth looking at the scenario, whether there have been those kinds of developments that would give the opportunity for some type of litigation challenge.
Yeah, thank you for that. I think it's a very important point. We didn't give much attention to the ways in which there's been pushback against a lot of these events. I'll also add that there is, I think you're quite right that there isn't a sort of body of law that says that parents have a right to include a particular set of materials. That's under the control of local school boards and the states and all of that. But there is a case arising from a situation that happened about a decade and a half ago, where in it's called Arce, I'll remember the name in a minute, Arce versus Duncan, I believe, where a local high school had adopted a ethnic studies program that included the history, Chicano history. This was a population that had a high population of Chicano students, and the Republican then school superintendent basically shut down the program after hearing that some of the students had reacted negatively to some person that had appeared in a school assembly. He basically took the action of shutting down this ethnic studies program, and the court in that case said it's exactly along the lines of what you just argued, that it could not, that while this, no parents could dictate what the particular curriculum could be, by the same token, the school superintendent could not shut down this program simply as a product of a reaction to what he thought was a negative response by the students. And so the basic idea in the case is that it infringed upon what the court called the freedom of the students to learn. Now, that has not been a concept that has been picked up broadly in a lot of these lawsuits, and to the extent that there has been litigation challenging some of these anti-CRT bans, most of them have proceeded under the First Amendment argument that they were vague and overly broad and impossible to comply with. But I think it is important to recognize that federal law and Title VI still does prohibit what's called a hostile racial learning environment. And so if there is such an environment and a school makes an attempt to address it, it cannot then be, I guess I would say, precluded from addressing those kinds of, for remediating that kind of condition. And so I think your point is really well taken.
We have one other question.
Yes. How do you respond to those who argue that we are wasting our time in engaging in these academic exercises, that Black people will never be accepted as full citizens in this society, that the only solution is for us to remove ourselves from it, either in a separate state or moving back to Africa, for so to speak?
I didn't hear the last part of the question. Could you, I think I got the gist, but I just want to make sure I heard the last part.
That the only solution is for us to remove ourselves from this society, either in a separate section of the country or a new nation for ourselves, or moving back to Africa in some manner.
Can I respond to that?
I also want to say something.
Sorry, I didn't.
Go ahead.
No, go, you.
No, I yield to you first.
Can somebody repeat for her what you said? I think she can't hear.
You didn't hear what you said?
No.
Great, Margaret.
No,
go ahead and because I was going to say something else.
Okay, I was just going to say, thank you for the question, that being recognized as full-fledged citizens of the United States and helping to build a multiracial democracy is just but one element of the right to self-determination that we as a people should have had after our freedom was recognized under the 13th Amendment. There were other options, and those options many of us admit should still be present today. Yes, multiracial democracy as a United States citizen is one. Repatriation back to Africa is another. Immigration to another place, Jamaica, Haiti, or whatever, is another. In the establishment of an independent nation state right here on U.S. soil, negotiate with the native peoples, etc., is another one. But we have been led to believe that the only option we have is the option that you just mentioned, and that is a false interpretation of what our rights are under the international law of self-determination. So I just submit that each one of those options should have been our province, and it still extends down to today, with full repair, reparations, amends, to make whichever option, whichever of us determines should be our political future.
I thank you so much, Nkechi, and I really support what you say. And, I also support the position that Paul Robeson took. in 1950 when he was being interrogated by a congressional committee, and he said, look, here I stand, my fathers, my forefathers, and my foremothers owned this country, made this country, built this country, and I'm not, this is where I make my stand. But I wanted to say something else about Derek's work, and thank you so much, Cheryl, for keeping it alive and keeping it at the forefront of our strategic discussions. But I also have to say that Derek's work is completed by the work that Cheryl herself has done to introduce into the idea of interest convergence, the theory of interest convergence, and its insight that all of us, of course, appreciate about the permanence and intransigence of U.S. racism, with what Cheryl has brought to the table on the question of capitalism. So you cannot really understand the place of racism in the United States or its permanence or the notions of interest convergence unless you fully appreciate as well the dynamic, the economic and dynamic incentives that are represented by capitalism. Derek did not express that. Much as beloved as he is, Derek did not take on that question, and I see that as a weakness in his work. Thank you, Cheryl, for the corrective. And I want to ask how you're dealing with that in your representation of Derek. But I also want to say one other thing because I'm about to leave. I'm sorry, I have to catch a plane. And that is going back to Justin's point about reparations. I am working with a number of other people on reparations project that looks at reparations for the victims of lynching and other forms of historical racial violence in the 20th century. And the way we're approaching this will be federal reparations based on the theory of the federal government to intervene, protect, and prosecute cases. This is an old idea, but now sort of trying to bring it to the fore and to get some legislation. But obviously we have to deal with SFAA, the lawsuit. And so one of the ways that we are approaching this is that although we know our folk, black folk, African-derived people in the United States were the primary victims of this form of torture, there were also other racial groups. And so rather than trying to meet strict scrutiny, we are knocking it down one level and bringing in other groups, other racial groups that were also victimized, Asian Americans, mostly Latinx, folk who were also victimized by these sorts of racism. And that is one other way, I think, strategically. Now, obviously, let me stop there. I could say more, but I'm going to stop there.
Thank you all. To return to the basic question, which I read as a kind of what way forward, I think I would say that we have been having this discussion, and as Nkechi, I think, pointed out, there are historical roots for thinking about why all of these questions and options have been historically part of our struggle, why there continues to be a return to this question about whether or not we see as our goal the creation of a multiracial democracy in the United States, or whether we see as our goal a sort of mass immigration movement. All of these things have been part of our history. I guess what I would say is one of the things that I think we, as a broad, again, going back to this idea of a broad coalition, can at least begin with is the idea that the project requires us to fight for space here and now in order to achieve any of those goals. And in that context, one of the things that I think that's important for to understand, at least as I think critical race theory brings to the table, is again this idea of understanding and diagnosing the particular forms and the way that racial oppression takes and intersects with all of these other societal structures, including, as Margaret said, part of my work has been to sort of think about its intersection with property and the way in which the very idea of property and ownership is itself racialized in this country. and what the implications are for then even a project that might be thinking about the question of developing a separate state, without the sort of attention to the ways in which capitalism structures not only this domestic economy, but the global economy as well. The question is, how would one in fact articulate an independent project that actually is not conscripted into capitalism? Because we can understand and see, if we look at some of the struggles of our brothers and sisters across the Atlantic, to see how neocolonial governments, in fact, participate in the global capitalist order by oppressing their own. So one of the things that I think critical race theory can give us is not, again, a kind of sort of strict pathway forward, but a way of sort of always understanding and analyzing the reality that we're in. The point that I guess I would also want to underscore is, if we have our understanding of ourselves as a working coalition, if we think about, going back to Bernice Reagan's famous articulation, which is coalition work is some of the most difficult work ever, right? It is very, very hard work. But it basically requires us to understand that at any given moment, we are all stronger together, and that requires not that we seek to suppress each other's difference, but that we seek to honor each other's difference and understand it. To some degree, that is, I think, going to be ultimately really crucially important in this period.
Thank you. We're actually out of time.
Thank you to Cheryl. Cheryl, thank you. These folks have been after you. Thank you for your scholarship. Thank you for your clarity. Thank you for your endurance. And we got your back. Fuck 'em.
Thank you so much. It means everything. Thank you.
Love you.
Love you all. Wish I was there.
Peace.
Thank you. Have a good one.